What I am about to tell you is not being discussed on CNBC, not being explained by crypto Twitter, and definitely not being broken down for retail investors the way it should be. Because a breaking Supreme Court development just quietly shifted the legal chessboard. And if you understand how this system really works, you will realize this could directly impact XRP holders in ways that most people are completely unprepared for. And I'm not exaggerating when I say this changes everything. So ask yourself right now, why would the Supreme Court, the highest authority in the United States, suddenly become relevant to digital assets at the exact moment the SEC, BlackRock CK, and the IMF are all accelerating their positioning around tokenized finance? And why is Ripple always sitting right at the center of these moments when the old financial system starts to crack? Let me be very clear from the start. This is not random. This is not coincidence. And this is not something you hear about after the fact if you are paying attention early, because what we are seeing is a legal pressure point forming at the very top of the judicial system that could ripple down into how securities law is interpreted, enforced, and weaponized, and XRP sits directly in the blast radius. Think about this logically for a second. If the Supreme Court begins signaling limits on agency overreach or questioning how far regulators like the SEC can stretch decades-old laws to control modern technology, what happens to the single most high-profile crypto case in history? And why would institutions like BlackRock CK, Fidelity, and even global bodies like the IMF already be preparing for a post-enforcement regulatory environment? This is where you need to slow down and really listen, because retail is trained to react late while institutions position early. And the people who win are the ones who see the signal before the headline. Quick pause. If you value this kind of real-time, no-nonsense breakdown that connects dots the mainstream refuses to touch, make sure you are subscribed right now and hit the like button, so this reaches every XRP holder who is still asleep. Because what comes next could directly affect how you view your position. Now here is the setup nobody is talking about. Supreme Court cases do not need to mention XRP by name to reshape the battlefield. They only need to redefine authority, interpretation, and limits of power. And once that happens, the entire SEC playbook gets exposed, and suddenly Ripple's years-long fight starts to look less like survival and more like positioning. Ask yourself this extreme question. What if the Supreme Court doesn't just influence crypto regulation, but detonates the very framework the SEC used to attack XRP in the first place? And what if that is exactly why silence from mainstream media is so loud right now? Now, let's move from intuition into authority and data, because this is where the narrative becomes uncomfortable for the establishment. And this is where XRP holders need to wake up fast, because the Supreme Court has been quietly sending signals for months about administrative overreach, about unelected agencies writing their own rules, enforcing their own interpretations, and acting as judge, jury, and executioner. And if you think that doesn't directly intersect with how the SEC went after Ripple, then you are missing the entire plot. Look at the pattern. Supreme Court scrutiny of Chevron deference, questions around how much power federal agencies actually have to interpret vague statutes, and sudden interest in reining in regulators who have operated unchecked for decades. This is not abstract legal theory. This is a loaded weapon aimed straight at the heart of the SEC's enforcement-first strategy. And XRP just happens to be the most visible casualty of that strategy. Ask yourself why legal scholars, former regulators, and even insiders connected to Wall Street institutions have started openly questioning whether the SEC exceeded its mandate in crypto, and why firms like BlackRock CK are suddenly comfortable filing ETF applications and expanding tokenization initiatives while the regulatory fog supposedly still exists. That contradiction alone should make you say WTF is really going on behind closed doors. Remember, BlackRock CK does not move without legal clarity. The IMF does not praise blockchain infrastructure without regulatory alignment. And major banks do not experiment with on-demand liquidity unless they are confident the rails will be protected, not punished. This is where Ripple's years of courtroom combat become critical. Because while other projects ran, hid, or settled quietly, Ripple forced the SEC to expose its reasoning, its internal inconsistencies, and its reliance on outdated interpretations of securities law. And now, the Supreme Court is circling the exact structural weaknesses that Ripple's defense highlighted from day one. Here's the part that should give you chills. If the Supreme Court limits how agencies interpret ambiguous laws, past enforcement actions don't just lose future power, they lose legitimacy. And suddenly XRP doesn't look like a risky asset, it looks like the test case that helped trigger a systemic reset. Think about the timing. Global institutions talking about tokenized treasuries, banks demanding faster cross-border settlement, the IMF pushing interoperability, and at the same time the highest court questioning the unchecked authority of regulators. This is convergence, not coincidence. And if you are still wondering why mainstream media isn't screaming about how this could impact XRP holders, ask yourself who benefits from retail staying confused while institutions quietly position ahead of a potential legal and regulatory pivot that could re-prick the entire digital asset market overnight. Now we reach the catalyst phase, and this is where the fear, uncertainty, and doubt is intentionally injected to shake weak hands right before the narrative flips. Because every time XRP approaches a structural inflection point, the same psychological warfare appears. Random sell-offs, sudden negative headlines, recycled talking points about lawsuits being over, but adoption being dead. And it's all designed to make you ignore the bigger trigger forming in the background. The catalyst is not a single headline, it's a legal domino effect. Because when the Supreme Court starts tightening the leash on agencies like the SEC, enforcement-driven regulation collapses under its own weight. And that means every case built on aggressive interpretation becomes vulnerable, not just in the future, but retroactively in credibility. This is where the FUD artists get loud. They'll say this has nothing to do with XRP. They'll say Ripple already won what it needed. They'll say the market doesn't care about legal nuance. But ask yourself this brutal question. If legal clarity didn't matter, why did Ethereum get a free pass? Why do institutions obsess over compliance? And why did Ripple fight instead of settling quietly like everyone else? The answer is simple and uncomfortable, because Ripple knew that whoever survived this phase would be positioned as infrastructure, not speculation. And this is where the Supreme Court becomes the accelerant, because once agency power is constrained, Congress is forced to act. And when Congress acts, lobbyists act. And when lobbyists act, the BlackRock Chiques and JP Morgans of the world make sure the rules favor scalable, compliant, enterprise-ready systems, not meme coins. XRP fits that profile whether people like it or not. The FUD will tell you banks won't use XRP. Yet Ripple keeps announcing corridors, partnerships, and integrations that quietly expand while Twitter argues price action. The FUD will tell you central banks won't touch public ledgers. Yet the IMF openly discusses interoperable digital asset infrastructure. The FUD will tell you regulation is bad for crypto. But in reality, regulation kills noise and crowns survivors. This is the psychological setup. Maximum doubt right before maximum clarity. And historically, this is the exact window where retail exits and institutions load. So the real question isn't whether the Supreme Court update matters. It's whether you understand how catalysts actually work in this market. Because by the time it's obvious, it's already priced in. Now comes the part that makes people uncomfortable, the price justification, and the final warning. Because this is where emotion collides with math, and denial collides with positioning. And if you are not ready for that, this is where most viewers mentally check out. Even though this is the most important section of the entire conversation, price does not move on hype alone. It moves when narratives align with legality, liquidity, and utility. And XRP sits at the intersection of all three. If this Supreme Court pressure continues to restrict regulatory overreach, think about what repricing actually means. It's not a random pump, it's the market reassessing risk. And when legal risk collapses, capital flows change direction violently. Institutions do not need XRP at $10 to justify exposure. They need certainty. And once certainty arrives, liquidity requirements, settlement demand, and treasury positioning start to dictate price discovery, not retail sentiment. This is why you hear whispers of triple-digit valuations and you instantly dismiss them as insane. But ask yourself a harder question. What is insane? A digitally native bridge asset handling trillions in cross-bar value, or a market still pricing it like a speculative toy because of outdated fear? If the Supreme Court effectively kneecaps the SEC's ability to stretch securities law, XRP's historical discount evaporates and markets don't adjust slowly to that realization. They gap. This is where the final warning comes in, because the most dangerous moment is not the crash. It's the calm before the revaluation when price goes sideways. Volume dries up, influencers get bored, and conviction is tested. That is historically when positions are transferred from impatient hands to strategic ones. I am not telling you to buy, sell, or do anything reckless. I am telling you that ignoring legal macro catalysts because price hasn't reacted yet is how people miss generational moves. The Supreme Court does not issue opinions for crypto Twitter. It issues frameworks that reshape power. And when power shifts, money follows aggressively and without apology. The only thing more painful than volatility is watching clarity arrive after you positioned for confusion. Here is how this ends. Not with fireworks on the chart tomorrow, not with a headline spoon-fed by mainstream media, but with a slow realization that something foundational shifted. While most people were distracted by noise because the Supreme Court update is not about XRP in name, it is about authority and principle. And principles are what decide winners when systems evolve. XRP holders need to understand that being early feels exactly like being wrong right up until the moment reality catches up, and by then, the opportunity window has already narrowed. Ask yourself this final extreme question. If the SEC's grip weakens, if enforcement-based fear loses its teeth, and if institutions are already positioning for a regulated, tokenized financial future, where does that leave an asset that was stress-tested in court, integrated into enterprise rails, and discussed in the same breath as global liquidity infrastructure? This is why the silence is louder than the headlines, because revaluation does not need your permission. It only needs clarity. And clarity is creeping in through the highest legal channels in the country. The mainstream will explain this after the move. Influencers will pretend they saw it coming. And retail will wonder why it felt so obvious in hindsight. The only decision that matters now is whether you are reacting to fear or recognizing structure. Because history does not reward comfort. It rewards those who pay attention when the room is quiet and the signal is